And that new issue, my Lord, has been identified as the fact that the National Assembly passed its resolution or considered and passed its motion, and that is what has then given a rise to this cause of action. My Lord, it is not disputed that the National Assembly passed its motion on the 8th of October this year. And again, my Lord, you will clearly see from the ruling of your brother, Mr. Justice Mugambi, that the parties before you today were before him on the 9th. On the 9th of October this year. And my Lord, the fact that Mr. Justice Mugambi's ruling of the 11th of October takes on board the fact that the challenge by the petitioner is both to the proceedings in the Senate and National Assembly, I submit that it was then the petitioner's duty in petition 522 when we were before your brother Mr. Justice Mugambi on the 9th to point out in petition 522 that there were new facts that necessitated his consideration of prayer number 6 in the notice of motion dated the 2nd of October that was before him. That prayer is the same prayer as prayer number 5 that has been urged before you today. That was the right thing to do. My Lord, that having not taken place, and the petitioner having elected to file this petition and the notice of motion that is before you this afternoon, that deed by the petitioner amounts to forum shopping. And I urge your Lordship, therefore, not to proceed and hear and make a determination on the notice of motion that is before you in petition 550 of 2024. My Lord, a possible way out or a remedy has been suggested by my good and learned friend, Mr. Macharia, that the remedy is to stay these proceedings. Or the remedy is to stay 522. My Lord, that request or that motion is not before you. And I submit that, my Lord, the correct thing to do, petition 522 being the first in time, and so as therefore, my Lord, not to be an accessory in forum shopping, what your Lordship should do is direct that this petition be consolidated with petition 522 of 2024, and any relief sought in notice of motion dated the 11th of November, 11th of October, 2024, be canvassed in the consolidated petition 522 of 2024. Any prayers, any relief that is sought, notice of motion dated the 11th of October, 2024, be canvassed within the context of that consolidated petition. To go on and entertain and make a determination as you have been invited to by the petitioners, would my Lord would then be facilitative of forum shopping. My Lord, my learned colleagues who will submit after me will submit extensively that the process which the Senate has now embarked on is guided by certain constitutional timelines. And in deference to those constitutional timelines, my Lord, the remedy that the judiciary has come up with is to acknowledge that the High Court's ability to examine, if it has that ability, is postponed until the constitutional process, governed by strict constitutional timelines, set out in Article 145, Subarticle 3, 4, 5, 6, and 7 of the Constitution, is completed by the Senate. My Lord, I am of the view that you should not consider any of the substantive arguments that have been made in support of the notice of motion in respect of public participation or otherwise. But, my Lord, if you are in the unlikely event minded to consider those arguments, I wish to submit that the total population of Kenya is not a factor to be considered when determining whether public participation was effective or not. Article 118 of the Constitution places an obligation on Parliament to facilitate public participation. But the public have no compulsion to participate. There is no corresponding duty in the Constitution that when public participation takes place, then all citizens or a certain category of citizens of Kenyans must participate. And, my Lord, if that argument were to be given any credence, then it would be possible to challenge the election of an elected official by reference to the turnout of voters. You are elected in constituency X where there are 20,000 registered voters. Only 2,000 came out and voted in the election in which you were returned. That is the way the Constitution works. There is no compulsion that everybody takes place. There is no threshold set out in the Constitution for a return on public participation. Again, my Lord, the reference to an opinion poll and to pollsters is again irrelevant in assessing the adequacy or the efficacy of public participation. I submit, my Lord, that in promulgating the Constitution in 2010, the people of Kenya were very deliberate as to the structures and institutions they set up. There are thresholds contained in Article 145, and those thresholds refer to numbers of members of Parliament, both of the National Assembly and of the Senate. And if there are any numbers to be referred to, it is those set out in Article 145. My Lord, there is an allegation that there was a resolution passed at night. And there was a concern at the speed at which the process is taking place. Again, in that submission, there is no statement that the second respondent proceeded or sat irregularly, or that the transition of the resolution from the National Assembly to the Speaker was irregular. My Lord, all of them took place within the prescribed constitutional parameters. And the speed at which any of those took place is not impeachable unless it can be established that they took place outside the time prescribed by the Constitution. My Lord, in respect of the order from your brother, Mr. Justice Mwongo, in Kerugoya, and I'm glad to note that my learned colleague, Mr. Ndego Njiru, is now present. When we were before Mr. Justice Mwongo, an attempt to make these submissions that have been made on the part of the petitioner, that there was non-compliance with that order, were made. Mr. Justice Mwongo, and you will see from the pleading, direct that nevertheless, that Kerugoya matter be consolidated with matter before the three-judge bench. And my substantive submission is as follows. There is reference to a petition in Kerugoya where Mr. Justice Mwongo gave certain parameters in which public participation must take place. I believe it is petition number 14.
It's in his supplementary affidavit.
It is in the supplementary affidavit filed as annexure RG 19. My Lord, my submission is that this cannot then be the forum in which that order is enforced. There is a direction that a bench will be established. I am not sure whether Her Ladyship, the Chief Justice, has established a bench. This matter is not consolidated with the matter where the Kerugoya matter has been consolidated. And it cannot then be a proper exercise of this court's jurisdiction to turn petition number 550 of 2024 into the enforcement proceedings or orders made in petition number 14 of 2024 in Kerugoya. I yield the rest of our available time to Mr. Gumbo and Mr. Wanyama to conclude our missions. I'm most obliged. My Lord, perhaps if you could be kind enough to add us some time. I was making submissions on an important issue, and I believe we all agree that it is important. My Lord, we are entirely in your hands. What we seek for is a little more time so that we can put the other issues. No, I would not ask your Lordship for the entire day. On top of what we have, my Lord, would you consider 10 minutes? Then maybe 10 minutes so that we conclude? We use the 4 that we have plus 6 more? What would sit well with your Lordship?
Because each one will leave us for time extension. So how much time is it?
I leave it entirely to you, my Lord.
Conclude. I'll give you another 3 minutes. That makes 7.
My Lord, have you factored in the time that we stopped? I must oblige, my Lord.
My Lord, allow me to, in a very brief way, just add to what my learned senior, Mr. Nyamodi, has